Welcome friends. Today we will discuss about the provisions regarding garnishee orders and attachment orders normally served on banks. What is a garnishee order? Garnishee order is an order which is normally issued by a competent court, and this order actually has been issued as per Code of Civil Procedure 1908. As per Section 60, Order 21, Rule 46, garnishee orders are issued on banks for attaching the funds lying to the credit of a particular customer. Similarly, revenue authorities normally issue attachment orders as per Section 226, subsection 3 of Income Tax Act. The limitation period for a garnishee order is 12 years, whereas the limitation period for an attachment order is 30 years. Normally, bank will consider these orders as a very important one, and bank will act immediately upon serving of such orders. We will just examine how this garnishee order is being originated. In the screen you can see there are two persons, namely one creditor and one debtor. The debtor has borrowed funds from the creditor, and of course the creditor has to collect the funds as per the terms and conditions, and at the time of due for payment of this amount, debtor has defaulted such payment. So in order to recover the amount from the debtor, the creditor will approach the court. Normally, the creditor will approach the court and he will file a suit in a court of law. So court will accept the suit from the creditor and it will examine the suit, and after perusing its different angles, the court will inquire about any amount lying in the name of this debtor with any of the bank. So normally the creditor will give certain information to the court that so and so who is the debtor, he is maintaining account with such and such bank. So with the information, the court will issue its first order to the particular bank. This first order is known as order nisi. In the first order, the court will ask the bank whether so and so is maintaining any deposit account with your bank, and if at all such a deposit is there, why can't you attach these funds as per this court order? Then it is the duty of the bank to reply to the court, and the bank sometimes may raise certain rights because the bank might have given a loan. In that sense, the bank is having an upper hand in recovering the amount from the deposit. That is known as the right of set-off of the banker. So suppose if there is a right of set-off available to the banker, and it has to inform the court that so and so has availed a loan against the deposit, even though the deposit amount is there, this much amount is due to the bank, and remaining we can attach the funds as per the court order. So immediately after getting a reply from the court, immediately after getting a reply from the bank to the court will issue a final order on the bank where the debtor is maintaining account. The final order is known as order absolute. In the final order, the court will give clear direction as to attach the funds of the debtor after adjusting the amount due to the bank. So this way, the garnishee order will apply. So we will see certain provisions in this garnishee order. And here we are calling this creditor as a judgment creditor and the debtor as a judgment debtor. Now I have given a comparative statement regarding garnishee order and attachment order. Issuing authority, if you peruse, in the case of garnishee order, it is issued by the court. In the case of attachment order, it is issued by revenue authorities. If you examine the legal provisions, garnishee order is issued as per Code of Civil Procedure whereas attachment order has been issued by revenue authorities as per respective act, maybe IT department or GST or even PF. There are two stages involved in Garnishee order, order nisi and order absolute, but in the attachment order only one order will be served. If you examine the liability, Garnishee order, the liability is a private liability, that means the dues are private, whereas in attachment order it is a statutory liability because the person who has defaulted payment, it is in the form of income tax or GST or PF. So it is a statutory liability. Regarding amount, in the Garnishee order, it may or may not specific. But in attachment order, always the attachment order will specify the amount of attachment. If you examine the applicability, Garnishee order will apply to present balance outstanding in the account. Future credits will not be covered under Garnishee order. Whereas in attachment order, present balance as well as future credits can be attached. In the case of a deposit account, demand and fixed deposit standing to the credit of the customer can be attached. Same way, in attachment order also it can be attached. But in the case of a joint account, the Garnishee order cannot be attached in a joint account where the order has been issued for one of the party. But in the case of attachment order, it can be applied to joint account also on the basis of pro rata. Garnishee order is not applicable for deceased accounts, but in the case of attachment order it is applicable. Garnishee order is not applicable for insolvent account. Similarly, attachment order is also not attachable in insolvent account. With regard to undrawn balance in CC or OD, in the case of Garnishee order, the court cannot attach the undrawn balance in the CC or OD. Attachment order, there also the undrawn balance cannot be attached. When you talk about the preference, Garnishee order will get a second preference, whereas attachment order will get a first preference. Why the attachment order prevails over the Garnishee order means, attachment order deals with the statutory liability, whereas Garnishee order deals with private liability. So this is a comparative study between the Garnishee order and attachment order. Thank you friends. We will come with another topic shortly.
If you like our content, do like, share and subscribe.